Section 209 permits the minister to do exactly what is done. Hence, I'm saying that the complaint should rather be whether it was rational for the minister to serve. So that's the something I'm making. So I'm saying that when you give the rationality test, it's a different test altogether. But I'm submitting that it is not unlawful for breach of separation of powers.
What is your submission to the provision that says that the use of voting machines is subject to the simultaneous utilization of the result?
We have dealt with it in the answer that we gave to say subsection 2 on the reading of section 7 is not dependent on subsection 3. There is no reference to subsection 3. But we say that the court should interpret what that paper trail is. And in our submission, in the answer of the day, we say that the paper trail is that which is intended to assist the voter to see what the voter voted for. So we can leave it at that level, and that is really the crux of our submission. So we say that it's not unlawful, it simply goes to rationality. And so far as rationality is concerned, we say we have provided a proper explanation as to why, about the checks and balances that we have put in place. So we can only leave it with it.
This determination by the minister, just to be speaking for myself again, unusual. In the course of the research, when we found instances in which the provision was brought into operation in this truncated way.
It is unusual but not unlawful. It may be unusual and unlawful, but if one looks at there is none.
The authority
from the Liberty Justice the authority for the proposition.
No, what the Chief Justice said is that it's unusual, not unlawful. So I'm responding to that. Unusual, yes, it may be, but it's not unlawful. And I'm saying that there is a reason that was provided as to why it is done so. There is a letter of 19 February 2019 from the ECN to the Minister, which explains entirely that the ECN does want to ensure that in future the paper trail is used and set out what still has to be done. But that does not make it unlawful. It simply shows that once everything that the ECN has raised is addressed, then the Minister will be able to promulgate the remaining parts of Section 97, and ECN will be able to use paper trail. But the short answer, Chief Justice, to this whole debate is that a determination has been made which is lawful, which is valid, and that ECN cannot be criticized for giving effect to it and implementing it. So that really is a short answer to it. And if there is supposed to be a debate about whether the minister was right or wrong 5 years ago, when nobody really bothered to challenge that and allow the administration of justice to operate on the basis of the lawfulness of the decision, and is challenged in 5 years later, we submit that it should start at the beginning in the High Court because nothing is urgent. But we say that all the ground principle clearly protects the ECN because it did not simply operate on the frolic of its own in contravention of legislation. It implemented the legislation as it is, Part 5 as it is. We have said in our heads of arguments that Part 5 of the Electoral Act starts from Section 63, and none of other provisions which were put in force by the Minister in 2014 are alleged to be breached by ECN. What we're told is that ECN breached a provision which was not put into operation, which is 97.3 and 4. And we say that there can never be a breach of a provision which has not come into place. Of course, we're not saying that nobody is entitled to approach court and set aside the decision of the minister. One can do that as long as then you do it properly and before the right forum. But Audiogram, as things stand, protects us, and the legislation, as we're speaking now, it is a legislation which does not have 97.3 and 4. So those really are our submissions.
Authority for the position that the delegation by the minister is lawful.
Yes.
If I understand it correctly,
Yes.
Section 209, the electoral.
Yes.
The any other authority, the vocational, that supports that opposition.
Well, it is the authority that the Parliament, or that it is not an anomaly for Parliament to delegate certain duties to the executive. And we say that Parliament is delegated to the executive through Section 209 to give, to put into operation the Act, and it also says that you can do it in different events. So that is the authority.
The short answer from your side is that you do not have case law on the point.
Well,
Or is there?
yes, I'm not referring to case in point in the sense of giving the case. I said that I will make it available as soon as Nigeria can find the case. It is in the bundle. Well, actually, I'm referring to, we didn't put it in the bundle, but I'm referring to pharmaceutical manufacturers case, which
So that doesn't deal with
our friend.
But that's not a point though, isn't it? Sorry, that doesn't deal with the truncated type of implementation that we have in force. It's to do with principle process.
Yes,
That's
yes.
been followed by some pharmaceutical case.
No, remember, I'm taking it further because it's
No, that's
smart.
the Chief Justice asked you, you've got authority for other cases where you have this truncated way in which any provision is put into operation.
No, it is, the proposition is the authority to support in Section 209 what the minister has done. So I'm saying that when you look at Section 209, it was enacted by Parliament itself. And that Section 209, it says that you, the executive, you are empowered to put into operation this act, and you can do it in different ways. So I am then taking it further myself to say the promulgation of Section 97, 1 and 2, with the exclusion of 3 and 4, falls within the powers that Parliament gave to the minister. So I'm making that submission, so that's what I'm saying.
Thank you.
There's a copy. So,
the additional provisions which have not been promulgated is to give some safeguard to the election. Am I right?
it's checks and balances
Yes.
for the benefit of the voter.
Yes. In the absence of that constitutional protection, what is the voter left with?
Well,
The voter is left with only the machine.
the machine and the printing by the machine. So the machine, because it's the machine and the printing by the machine. Because what is put, which is not in dispute, is that the machine, the manner in which it has been manufactured, it is capable of printing the results in the event of a dispute.
No. That's factual.
Yes, factual, yes.
It's factual.
Yes.
We are concerned with the legal question.
Or then in that context, of course, then in that context, I understand.
He says right from the beginning that this matter is the legal question. Deal with the So we found that legal protection with subsection 3 and 4, 6 to give to the voter. The voter is left technically with the machine. That does not give him or her the protection in sub 3 and 4. Am I right?
No, not entirely, but partly. The voter is left with the machine and other safeguards of.
In other words,
Well, first, the conduct of the elections. It starts with the verification of the machines by all the parties.
so is that with due respect to you. Let's go forward to the provision that you interpret.
Yes.
Section 97, that's what we're here.
Yes.
Let's look at this. Let's not look at this extraneous to the piece of legislation being argued. Parliament says 1, 2, 3, and 4 will happen. The President assents to this piece of legislation. He signs it into law, and what it remains is for the minister to promulgate it in terms of section 4.9. Now the question is, does the Constitution allow the minister to do that selective promulgation, given the fact that this provision cannot be read as real? We cannot read it. It is a thread of a provision that we have to read to its conclusion.
Justice Nkabinde,
This is what Mr. Gowland is arguing.
well, Justice Nkabinde,
Now, if he is correct, if Mr. Gowland is correct, how can it not be so that separation of powers is being breached? Parliament speaks for the people of this country. It makes law, the President agrees, it assents, it signs, and someone decides, I'll only promulgate certain part of the whole.
can I respond, Justice Nkabinde?
Yes.
Yes. I've provided my submissions when the questions were put by the Chief Justice, and I've made it clear that our submission is that this does not breach the separation of powers, but I would like to return to it because otherwise it's going to detain me long. If I can deal with the points, but my submissions then are those that are related to this particular topic. But I just requested that I return to it at the end. But the submission that I've made is that it does not breach Section 209 because the Parliament has delegated that to the Minister. And I've said that insofar as the severing of Section 97 is concerned, we submit that it goes to the nationality test. So that's how we deal, not the unlawfulness in the context of separation of powers, principle of breached.
Before you deal with the topic 5, the regularity.
Not 5, I'm still going to deal with Malaysia.
Are you still on order cloud?
I'm still on 4. I dealt with audit crowd, then I dealt with the substantive merits of the application. And so now I'm going to conclude topic 4 then with Malensky, and then from that go to 5. So I just beg you to briefly deal with Malensky. I'm not going to take care of time.
Okay, but before you go to the next on this very topic, if we are minded to agree with Mr. Conflict on the declaration, what effectively means
topic 6, which is going to deal with the remedy.
Or we'll deal with the remedy in relation to 2 and remedy in relation to 5.
Yes. Which I'm going to deal with remedy in relation to everything.
Yes. Move on to the next one.
Okay, that's right. In respect of what I've said about the decision not being set aside for the minister and the Electoral Commission being entitled to rely on it, without reading to the court, I just want the court to note the following passages, and that is now is going to answer Justice Kavile and Justice Mart's questions about where was the applicant supposed to go to and so on. If I can take the court to page 63.
Are you on the founding page?
Those are the founding papers. Actually, let us start at page 61. Annexure 8. This is the opinion that was authored by the first applicant which he gave to the ECN. And I'd like the court to note paragraph 4 at page 63, where the first applicant says that the argument that the EVMs without a paper trail are not transparent was rejected by the High Court. So that's how I'm introducing Malesky, and it's referring to the Malesky judgment in that regard. And if we turn to page 64, paragraph 6, and there he says this is most likely to be the same stance the court will hold on this particular concern again. There should be concrete factual evidence that was electoral fraud in the use of EVMs. It's not enough for the complainant to applicant to allege that there will be electoral fraud. That amounts to mere conjecture because the sections requiring the paper trail are not enforced in terms. The ECM is not bound to make the paper trail available. And if you can underline the way he said that the ECM is not bound to make the paper trail available, neither can they be compelled to do so. But if we look at page 67, paragraph 15, he says that it is clear that as the law stands now, there is no law which prohibits the Electoral Commission of Namibia from running elections using EVMs without a paper trail. The only thing an aggrieved person can do to challenge the election result in court once announced is required by Section 110, and as a result of that failure, no further proceedings could be had on the application according to Section 110(3). And then lastly, he concludes I want to take it just to the further part of the passage where he says that any aggrieved party must approach the High Court to compel the government to bring into force the operation of Section 97, 4 and 3 and 4, that is 65, the bottom of page 65, paragraph 11, and it ends at page 66. At paragraph 11 it says there is need for the production of a paper trail in Namibia with the suspension of section 97.4. This means that the aggrieved party should approach the court with an urgent application before the High Court to compel the Electoral Commission and the responsible minister to put into effect subsection 3 and 4, which are still suspended. So now we know that there was a challenge of this nature in the High Court by Manesky, and there is a judgment or a written judgment. In fact, we have included it in our bundle. That will be page 220 of our bundle. It starts from page 220 of our bundle. And in our heads of arguments, we have actually quoted the relevant paragraphs from paragraph 15 at page 224 to paragraph 21. But in essence, the point we're making, and there seems to be no dispute in this regard, is that the High Court in Manesky did make findings about the use of EVMs without a paper trail, and that there's nothing unlawful about that. If you want to challenge that, then you must come with factual evidence. We know that the applicants are saying that the High Court judge was wrong. Of course, they're entitled to say anything about that judgment, but the point that we are making is that this issue did present itself before the court of law, which makes decisions which ought to be respected by everybody. And we say that based on that judgment, the 2014 elections took place. This judgment has not been set aside by any court, and is the one that was able to give comfort to the ECN to conduct all subsequent local government and by-elections under it, including the 2019 elections. So we're saying again here that this judgment has not been set aside, but we accept that this judgment is not binding on this court, because there is a judgment of the High Court, but we're simply setting out the legal principle that as long as it is not set aside, it is an authoritative judgment on the use of electronic voting without a paper trail. So the ECN was perfectly entitled to act in accordance with this judgment. And in fact, on the passages that I've referred this court to from the opinion of the first applicant, he also appreciated that this judgment has rejected the argument that the use of EVMs without a paper trail are not transparent. And he said that somebody must go to court and try and get in order to compel the government to put into operation these provisions of the law. And that is the effect of Manesky. We're not saying that, we're not raising the rest judicata in the context in which the applicants are arguing it. We're not saying that it's the same parties and so on. Obviously, it's not the same parties here, we know. But we're arguing the legal principle that it decided definitively and conclusively on the issue of the use of EVMs without a paper trail. But of course, we do say in our heads, it may be that at some other time, this court disagrees with Manesky and overturns it. But once it overturns it, what are the effect of that is what then we deal with under remedy. So that concludes our submission under topic 4. Then I move to topic 5.
Something. What is the significance of these paragraphs in the opinion of the applicant?
The significance of which paragraphs?
The paragraphs that refer us to from the opinion rendered by the first applicant. What is the significance of that?
No, it was an introduction to Manesky to show that the first applicant was aware about Manesky and the effect of Manesky. So that I was raising it into context. I'm not saying that these paragraphs are binding on the court. So I'm not raising it into conscience. I'm just saying that he refers to Manesky, he was aware of it, and he understood the effect and the implications of Manesky. So that's maybe what I'm getting at. So can I come to topic 5? Chief Justice, I don't know to what extent I have to be extensive on a case that was not made at all in the founding papers and was also dodged in submissions by the applicant, which is irregularities. Really. But in short, the way I understand the submissions by the applicant is that when we only managed to get only 16 polling stations, we did not verify other 4,000 plus. That on its own is the end of the case on irregularities. Because I'm not saying that we can submit evidence to the court that in fact this irregularities are widespread. Now what we're told is that no, then we could not actually verify because of time and resources. So now the court knows that nothing was done to verify in respect of the other stations. But there's a fundamental even issue to that statement, is that in terms of section 172, the aggrieved party is entitled to approach this court for an order to review electoral material. In fact, if the court looks at the first letter of 3 December 2019 from the first applicant's attorneys, it was actually then going that direction. And the response to that letter was that, but you are asking us when you are supposed to invoke section 172, you're supposed to ask the Supreme Court, because the one that is empowered to do so, especially when you have regard to section 114 of the Electoral Act and 114 of the Electoral Act, which prohibits the Electoral Commission from disclosing the electoral material to anybody. And it is understandable. Why? Because the vote is a secret vote, and when the electoral material is produced, it must be by the order of the court having satisfied itself that in this case, the interest of justice requires that the electoral material should be opened. So what now we know is that there was really that request was not persisted with, not on the basis that there was no paper trail, but without any explanation. What was said for the first time that in fact these elections must be impugned on the basis of ministerial decision, it came then later in the letters which were being exchanged. But the first letter really then wanted the electoral material, and which then was never persisted with, and we say that the submission to be made now to say that, well, you must still make a finding that there were some irregularities, but we say that we were only able to look at only 16 polling stations. It's not good enough. But let me briefly just demonstrate to the court how far-fetched these allegations about electoral irregularities were made, and we can only submit after I've concluded referring to the court. I've prepared just a brief summary just for the court then to note the following. The allegations regarding irregularities are found from paragraph 95 of the founding affidavit to paragraph 114. In respect of these paragraphs, they mention 16 polling stations, but in the court, on the basis of what has been said, in the supplementary answering affidavit of the ECL, instead of 16 polling stations, we have only 15 polling stations. Why? Because the supplementary answering affidavit of the ECL makes it clear that in fact there is no polling station called Ojomuis, and we are charged that the polling stations in that regard, and that allegation has not been disputed. It doesn't exist. So that's what we say in our supplementary answering affidavit of the ECL. But then, even in respect of this remaining 15 polling stations, We know that the applicants say they've put 10 confirmation affidavits of the first applicant's electoral agents. In respect of this 10 standard confirmation affidavits, they confirm only 7 polling stations, and then the following. The court will see it when reading paragraph 25 to 114. So, first let me say that, let me give the court the polling stations where no confirmatory affidavit is filed. Villa Colorful, OS Center, MTC Building, Havana, Grootfontein, Base FM, and of course I mentioned Ojo Muse, which does not have a confirmation as well, and Olaf. There is an affidavit, standard confirmatory affidavit of a gentleman by the name of Ngeno Misho, and this Ngeno Misho simply deposed a standard confirmatory affidavit, does not even say in which polling station he was accredited, in which polling station he was. Then paragraph 95 seeks to deal with his allegations. But in paragraph 95, what the first applicant mentions, he mentions 3 constituencies and 3 polling stations. That Ngeno Misho gave you the information about that. And we say that it's not possible for him to have been in 3 polling stations and 3 constituencies at the same time, because one electoral officer is accredited to one polling station. And that is in the supplementary answer affidavit, it's not been disputed at all. So what we remain with the court, we really are left with only 7 polling stations upon which confirmatory affidavits have been provided with a standard confirmatory affidavit. But over and above that, each of these polling stations, substantive confirmatory affidavits have been given by the presiding officers of these various polling stations and denying allegations. They are not standard confirmatory affidavits, they are substantive. And so we submit that on the basis of what this court has said in the RDP case, that is Rally for Democracy, the 2013 judgment or reported in 2013 paragraph 143 and onwards, is that allegations must be proven. We have referred as well to one South African case which assists in respect of elections, although it was dealing with elections, or a conference of a political party, the ANC of Ramaphosa, will attached it to the judgment by Justice Mseneke, Justice Kavinde Sefton judgment, so she knows it very well, from paragraph 94, dealt with how disputes of facts should be dealt with when allegations about elections are made, and plus what events applies. So we submit that on the basis of the allegations that there were irregularities, the allegations made are clearly far-fetched, and in certain instances then they were shown to be palpably false. And so this court will simply reject them, and it is understandable why the applicants do not seek to upset these elections on the basis of irregularities. But they are also aware of the provisions of section 115, which say that elections are not set aside on the basis of mistake or immateriality. In fact, if I may refer to it in order to deal as well with non-compliance with Part 5. If we can go to that section 115, it says no election may be set aside by any competent court by reason of any mistake or non-compliance with this part. If I may pause here. So, by reason of any mistake, and we know that on the irregularities, then their case falls flat, but then they say that they want to rely on the second part, that they are saying that these elections have contravened Part 5. Because when section 115 says this part is Part 5. So they're saying that was non-compliance with Part 5, and if there is non-compliance with Part 5, then Section 115 does not come in because the elections were unlawful. But then they're clearly wrong on the clear reading of Section 115, because Section 115 says no election may be set aside by any competent court by reason of any mistake or non-compliance with this part. So it means that even the non-compliance with Part 5, it must still be material to vitiate the elections, because then Section 115 is there to protect the elections, and here we know that we're only dealing with non-compliance with a provision that was never put into operation, and with a provision which the court has already ruled on, with a provision which we know that on the basis of Odikra then has remained as a valid and lawful provision. So we submit that even if the court were to give the applicants the benefit of the doubt in respect of those 7 polling stations, 4 of which do not, or 3 of which do not even mention which of the machines did, whether it was presidential or national assembly, then they're left with really nothing because of the provisions of Section 115 of the Electoral Act. So we submit that the court should simply, on the basis of absolutely no evidence on irregularities, to dismiss the application. Then I come to the last point, which is a remedy. In respect of remedy, so I am dealing with the remedy in the context of if the court grants the applicant's primary relief. Because if the court does not grant the primary relief, it is then the court upholds a point of jurisdiction or it upholds a point of delay. So the remedy doesn't come in. So I'm dealing with the remedy in the context of the debate we had, Justice Gavin, about whether the court has a discretion to grant or not to grant a declaratory order. So we are in agreement that if the court finds that the case is established for a declarator, it does not have a discretion, it must grant a declaratory order and then to declare invalid or unconstitutional conduct of act. Then, from there, it will then go to the next stage. It will then say, what is the appropriate remedy in the circumstances? So I'm dealing with remedy in that context. So I'm dealing with the remedy in the context that the court has granted a declarator, and now the court asks the question, what is the appropriate remedy? In this regard, it seems to be the third principle of the law is established in judgments such as all pay in the Constitutional Court of South Africa and the reforms South African Constitutional Court, which have been referred to by this court in the past, and as well as the judgments of this court, that a remedy must be an appropriate remedy tailored to the facts and circumstances of the case, and that the court takes into account all relevant factors. So here, we say that first, the grant of a declarator will not entitle the applicants to a consequential relief of the setting aside of the elections for the following reasons. One, we invoke as well the provisions of the Constitution such as Article 1, Article 5, and Article 25, because those are the rights of the citizens of Namibia, of their right to exercise their right, and the constitutional right to vote, and they must do so in free, fair, transparent, and credible elections. And we know that the applicants say that they are not impugning the integrity of the ECN, nor the credibility of the elections, but they are impugning a law, which has contravened the elections, which is the failure to implement section 7, 3, and 4. So we say that that is a factor that the court will take into account when deciding on an appropriate remedies. The question of the financial consideration.
I understand the sequence of the reasoning in relation to what we need to do after invalidating your mandate. Shouldn't that be considered the effective remedy in relation to the invalidation
Yes.
of the conduct? Shouldn't we consider a specific order directive the competent authority here in the position of the minister to do the correct thing?
Yes, I'm coming to this. I agree that it's one of the.
But maybe you should do it like now, because now you have gone to 6. Once we invalidate, then you say, what you then say, the own effective remedy, which the court must fashion as to what is said.
I'm not yet on 6. I'm still on 5.
Yeah, but you said, okay, let's understand. If you're minded to invalidate the declaration in
2 and 3.
2 and 3.
Well, 2, then 2 you invalidate, 3 you set aside.
Yes.
Which, but they're not together. The applicant yes.
We should just mention that you must not consider appropriate or effective remedy following the invalidation. Now I'm asking, will it not be appropriate then to fashion a specific document directing the competent authority to do certain things?
Yes, absolutely.
Yes.
Absolutely.
So I'm asking you.
That is one of the available remedies.
You can question that when following 2, 3 and add another sub-order following the minister.
And no, I mean, I was saying that there is one, not one, is 2, which is the declarator and the invalidity. Then 3, I say is a standalone because it doesn't follow automatically that when the court grants 2, then it grants 3. That's the point that I'm making. So the court will still exercise a discretion in respect of 3 and also in respect of 5. 4 and 5. So that's the point that I'm making. But I agree with you, Justice Kamini, that at the end, the court will then say, can we fashion a remedy which will enable the executive to remedy the defect?
What remains then is 5.
Why not get at 5? Well, I mean, let's go back a little bit because I know I've dealt with it, but I don't want to be confused. Let's still go back to 3. So what I'm saying is that maybe let's deal with it whilst looking at the notice of commission.
Rather than that, I just wanted to examine your statements about the applicant's status. They're not really impugning the integrity of the ECD, but they are impugning the transparency of the election and the system of paper track. I think you must be
Well, that well, whilst I say that the election is transparent, you have an answer affidavit of the ECL which says that they were transparent. You have the affidavit of Rao which tells us about the transparency of the machine. Then finally, you have the report of Shiham, their own expert. And maybe let's go to that report and see
I'm
what
not
it says.
giving you my opinion. I'm just saying you're characterizing the case that they didn't question the integrity of this, that they actually didn't impugn the transparency of the election. I'm just
Well, yes, I know that they are saying that they're not transparent. So I'm just responding to that in respect of the papers. So I'm saying that that is answered by the affidavit of Rao and the report, the 2009 report of Shiham, where she hammer says that these machines are transparent. So I'm saying that issue, whilst they are saying that they are not transparent, is a technical issue which is decided on the basis of experts. So that's what I'm saying. So if you can look at the notice of motion, page 3. So what I'm saying, Justice Salami, is that prayer 2, and let's suppose prayer 2 is granted because it's a declarative.
Yes, but you said that you will not be with the basis that 2 will be demanded.
Yes, 2 is granted. Yes.
Invalidating the content.
Then after that,
based on that,
then
there's no need to be free. Does it follow? Once you don't have,
it has to. I think based on all pay, it has to because you invalidate, then you decide whether to set aside. It's the same context. It's the same context with the tender, for example.
but once you invalidate, finality, you can't now set aside something that is not there. You have constitutionally invalidated the content.
Well, I understand that analogy, but when one reads all pay, when one reads even Article 25 of the Constitution, it is the invalidation. And then once you have invalidated, because Article 25 gives this court the power to fashion an appropriate remedy, including suspending or even making it corrective instead of retrospective, because there's a default position. The court then exercises discretion and says that, do I now have to set aside this conduct of the minister? And then from there, it looks at those factors that the court has set.
But I thought that invalidating the issue and for the directing the minister to correct the condition, that is what.
Yes, I accept. So all I'm saying that you're absolutely correct that if you grant prayer 2, then you're not going to grant prayer 3. So you move on and then you look at now what is an appropriate remedy in this circumstance. I mean, I will agree. And that will include whether do we have to direct this executive to do certain things and within a certain time. And that's what we say in our heads of arguments, that there are a wide range of options available to the court under its judicial discretion. For instance, the court will then say that when was this decision taken? It was taken way back in 2014. What has happened after that decision was taken? All this is objective facts that the court takes into account. Then the court then says that it will not be just an equitable or in the interest of justice based on the order that was granted of the declaration of invalidity to set aside the elections which have taken place, and including the fact that even the 2014 elections have taken place, and that they have taken place on the basis of the judgment of a court which is a competent court, and of a decision that has not been set aside. So that now the court takes into account all those factors, and then it concludes and says that the minister should, within some number of days or months, bring into operation section 97, 3 and 4, and that the order of invalidity is suspended, or the order of invalidity will not be effective, whatever. So those are the powers that fall within the discretionary powers of the court. So that's what the court will be looking at. I'm just giving the court the objective facts that the court will take into account in the case of this nature. Of course, if the case was predicated on massive fraud, corruption, and all those type of things. I mean, Justice Kade will know, I mean, how the South African courts have frowned on such acts as fraud, corruption, that the court said that it will not hesitate to set aside them. But these elections are not attacked on the basis of that. They are simply attacked on the basis of a legislation which, in bona fide manner, ECA implemented and conducted several elections in respect of it. But the other factor that the court will take into account, which is based on objective facts, is that the applicants are not suggesting for a moment that the declaration of invalidity should lead to the setting aside as well of the National Assembly elections, which took place at the same time, same place. That also is a strong consideration that the court will take into account in order not to make such a decision.
Look, in all fairness to you, Mr. Mokari, that's not what they suggested. They said they cannot suggest that because it's out of the scope of this type of application. This application can only be presidential elections. Therefore, they don't have a few next elections. They did not say, they did not suggest that nothing should be done.
Let me put it this way. Maybe you can never put it in a manner that suggests otherwise. They say that they are attacking the presidential election on not the National Assembly outcome. So let me stop there and say that both of them occurred and took place as a result of the 2014 determination. So that's the point I'm making. Secondly, what I say is that we could not attack the National Assembly because of Section 172. Because Section 172 only permits us to attack the presidential elections before this court. So that's not good enough because Section 114 permits any aggrieved party to attack the National Assembly elections and the electoral. So that's not an answer. So that I'm saying is a factor that the court will take into account. I'm raising it in that context. It's a factor. It has to be taken into account. Why legal policy will dictate that the court will set aside the presidential elections on the basis of a ministerial determination of 2014, but not the National Assembly elections. It's an important consideration for the court to take into account. It can't be ignored. And also, the court will also take into consideration the fact that the 2014 elections were challenged and the court sanctioned them to continue on the same basis of the same determination of voting without a paper trail. Is a factor that the court will take into account, even in circumstances where this court may differ with Justice Miller in Malaysia. And we say that all those factors taken into account, they militate against any order of setting aside the presidential elections, which are not impugned in the case of corruption and fraud. But finally, let me then refer to Article 25 of the Constitution. Article 25(1). So the Constitution in Article 25(1) it reads as follows. Save insofar as it may, and I'm only confining myself to paragraph A. Article sub 1, paragraph A. Save insofar as it may be authorized to do so by this Constitution. Parliament or any subordinate legislative authority shall not make any law, and the executive and the agencies of government shall not take any action which abolishes or abridges the fundamental rights and freedoms conferred by this chapter, and any law or action in contravention thereof shall, to the extent of the contravention, be invalid. And so that's really the declaration. And then it says, provided that, and that is the provision of paragraph A, a competent court instead of declaring such law or action to be invalid, shall have the power and the discretion in any appropriate case to allow Parliament, any subordinate legislative authority or the executive and the agency or government, as the case may be, to correct any defect in the impugned law or action within a specified period, subject to such conditions as may be specified by it. In such event, and until such correction, or until the expiry of the time limit set by the court, whichever be the shorter, such impugned law or action shall be deemed to be valid. And that is the point that Justice Legality was raising with me. And that will fall squarely within the jurisdiction of this court. And the other consideration that the court will take into account is the delay in this, because the determination and the Electoral Act has existed as a lawful and legal instrument for over 5 years. It's a factor that the court will take into account. The financial consideration, this court, in a rally for democracy, did not suggest for a moment that financial considerations is not a consideration at all. All what it cautioned, because it was quoting from the High Court judgment, was that in cases where it can be proven that there's fraud, corruption, and non-compliance with the provisions of the Act, then the court will not hesitate to do the right thing and will not be deterred by the financial considerations. But that must be understood in context. It is a fact-based inquiry. So, in circumstances where there was a massive fraud, corruption, or a complete disregard of the law by the ECL, is a factor that the court can take into account and say that in this case, we are not going to come to assistance, but we must set aside this. But here, the facts are completely different, because we are dealing with the situation where the ECL followed the law as it exists to the latter. Whether it later gets set aside that law as invalid, then is a factor that we will take into account. So we submit that the fact of this case strongly militate against any remedy which will result in setting aside of the 2019 presidential election, because it will otherwise cause untold chaos in the administration of justice in the state, given that elections continue to be run in terms of that act as it is, including the elections, the by-elections which took place yesterday, where the opposition were celebrating together with the first applicant. But it is still the law. So we submit to the court that the following orders should be made. Let me first then deal with the court, because I understand from Mr. Downton, he says that even if they do not succeed, then the by-wash principle applies. But we say that based on the serious allegations that they made about the irregularities which they could not substantiate, then we say that the by-wash does not protect them. And the delay, of course, is a factor that will be taken into account. And other conduct where they filed affidavits, where they were making serious allegations. The court has seen the further affidavit that was filed, which was making serious false allegations, including the first applicant saying that his photo was appearing in the machine that was recovered. And we filed an affidavit to say that, and that's the affidavit filed by the chief electoral officer, to say that in fact, to say that there was no photo.
Is the photo a video? He said his photo or a video?
No, it's not a photo. And we say, Chief Justice Reagan, people must really not make serious allegations. This is dangerous, because we talk of democracy. People rise up because of this type of things. People must be careful when they make allegations. We come up, we say that. And majority of David says that I was called by the police to come and inspect the instrument. It was a control unit, and a control unit does not have a photo of the person. And that is never replied to. It's never denied in reply. So we say that all these factors must be taken into account in respect of costs. But if we succeed, we insist that we're entitled to costs, And those, in respect of the first and second respondent, it will be the cost of 2 instructed counsel, and also in respect of the third and fourth respondent, which will be cost, which includes the cost of 2 instructed counsel. So, in conclusion, then the following orders will be made. In respect of pairs 2 and 3 and 4, this court should dismiss this application on the basis of jurisdiction that doesn't fall under Section 172 of the Electoral Act. In respect of paragraph 5 and 6, this court should dismiss them on the basis that the applicants did not prove any irregularity and the owners did not shift to the respondents to establish that the elections can be saved by 115. But in any event, even if the court will find that they established some of the irregularities, we say that cases should nevertheless be dismissed on the basis that the elections are protected by 115. So those are submissions.
But even if the applicant loses, as you suggested, will any order or possible mortality be in a matter such as this one?
Well, because it's a matter of importance, really, the court is a discretion. The court is a discretion. But I'm not leaving them off the hook. I'm saying that I'm still submitting that they should pay the cost. But I'm not saying that I am.
But are you making a submission from where you stand, given your knowledge of constitutional jurisprudence, about the cheating effect of those kind of laws?
Yes, but that's why I'm saying that I'm not going to prescribe to the court about the cost. I'm aware of the constitutional judgments, especially in South Africa. But I'm saying that my instruction is still the same. But I'm not forcing it on the court. So I mean, it's at that level.
Thank you, sir.
Unless there's anything, then those are sufficient. As a court, please, for just a moment.
Yes.
I'm indebted to the bench for really the extended time, and also that Mr. Gauntlet is the one who made me then to take more than 2 hours, but I never made any promises. As a court, please.
Thank you.
Thank you, Chief Justice. My learned friend complained for you, not for his own duration.
So you can go to rather than right. Like to David.
Yes.
Mr. Bond,
Yes,
in your reply,
Yes, sir.
it's for my own purposes. I'm a little bit apprehensive to run to the conclusion that the minister was wrong.
I'm sorry that the minister was wrong.
You can't hear me.
Yeah, I'm afraid
I'm saying I'm a little bit apprehensive to run to the conclusion that the minister was wrong. One, for the reason of the say-so on the opinions, especially in the light of the fact that he could have been under the mistaken impression that he was empowered by Section 2092. It seems to me that the subsections of Section 97 he put into operation are consistent with the right to vote in Article 17, the definition of vote in the Act, and the dictionary meaning of vote. If you were to go to page 16 of the Act, it says or the definition of voting machine means any machine or apparatus, whether operated in electronic electronically, digitally, or in any similar manner or otherwise used for the giving and the recording of votes. 2. A person interpreting or applying this act must do so in a manner that gives effect to the rights, freedoms, and responsibilities contained in the Namibian Constitution, and take into account the Bill of Fundamental Voters' Rights and Duties and any other appropriate law. Now, my question is, can one, under these circumstances, can one say the applicants were denied the right to vote?
Thank you. May I deal with that first, and then argue backwards on the issue of remedy, and then deal with the group of jurisdictional factors, and then the heart of the matter which we reached just after 3 o'clock, which is whether there's any answer to the Section 172 point. But if I might start with Justice Mainga's important question. Justice Mainga asked whether the court could know or not know whether the minister was under a mistaken impression that he was authorized to do what he did under Section 209. Justices, I have no doubt whether what's before you, the minister was under a mistaken impression. We said earlier that we impugn no evil intent to the minister, as we don't to the commission. We certainly say, and Justice Smuts with respect correct, we say that the election was conducted by the commission other than in accordance with law. But it's not enough for the minister to say, gosh, I was under a mistaken impression. Our attack is one of vires, powers. The minister can be as inspired and well-meaning as he likes. But if, as a matter of law, he was not entitled to choose parts of 97, but had to take 97 as a package, i.e. 1, 2, 3, and 4, or not to take it, or not to implement it rather. It's a matter of powers. And we have to be very clear on that. Because our learned friends started to argue about whether it was rational or not rational. It's not the point. Not the point. The point is that the Act, and Justice Mainga takes us to the definitional provision which provides or defines a voting machine, etc. But it's all predicated upon 97 being in operation. And the question is whether we know the whole of 97 wasn't in operation. And the question is, could the minister, congruent with the separation of powers and the Constitution, say, I think 1 and 2 do it. They do it for me. I think it gives, and this is implicit in Justice Mainga's last question, when he asked me, can one say that applicants were denied the right to vote? Let us be very clear. They were denied the right to vote as Parliament framed it. Parliament framed the right to vote in terms that there could be electronic voting if the conditions were met. The minister took out the protection, or rather didn't gazette them, didn't put them in. And what did that mean? Well, you've heard from our learned friends, they accept that, as does that important document at page 199, that first of all, for the ordinary person voting, you have protection when you push the button and noises are happening, you know what it means, and the colors flashing. You see a protection for yourself. Ah yes, the machine has it right, I voted for X. That's the first protection. And the second protection you have is that you're not just relying on the software. Because the lesson from several countries around the world, as we all know from our phones and from everything else, is they go wrong. We also know some very unfortunate other things in relation to software and the conduct of elections. So our unequivocal answer to Justice Mainga is, number one, it doesn't matter what impression the minister was under. We would accept that he might have been under a mistaken impression. It doesn't help him. It doesn't help anybody. The point was whether he had the power to put in half of 97 and not the other half when the two are conjoined by a subject to. And you've heard no, with respect, convincing argument from the other side in relation to that proposition. And then the second thing is that it is not the vote that the citizens of Namibia are given when Parliament says, all right, we know that electronic voting can be very nice to do things, but we also know implicitly, because that's why 3 and 4 are there can be problems, which is why we say you must have a paper trail. And we even go further and say that if there is a dispute or a discrepancy, the paper wins. They didn't have that protection, didn't have that assurance, so they didn't have the right to vote in its fullness. And which brings me to an important point raised by Justice Nkabinde. As Justice Mayengo also correctly read to us, the definition clause also ties it back into the Constitution, where it says, as contemplated, whatever it is, in terms of, the definition of voting machines, taken to do so in a manner that gives rise to the rights, freedoms, and responsibilities contained in the Namibian Constitution. What are they? Very shortly. Justice Nkabinde has referred to them in the course of argument. There's 1.1, Section 1.1, Article 1.1. There's 17. There's 28, and there's 94B. And they're very important because they anchor the Act. The Act must always be viewed through the lens of the Constitution. It can never be read down. It's always got to be read to give effect to the Constitution. And my learned colleague, Ms. Angula, drew my attention to one aspect I should have mentioned before in this very context, and that is there's even a provision in the Electoral Act in 2014 in Section 1.1, I think it is, which, thank you, it's the interpretation of provision saying that this must be read. I thought it was another provision. It might be the very point Justice Mayengo took us to. But the long and the short is, every single provision in the Electoral Act has to be read to give effect to those constitutional rights. And the constitutional right is not just that you push something, you don't know what's happening and you walk away. The constitutional right is that you've got dignity as a person to know how you voted, and secondly, you have the assurance that you're not just reliant on software from Japan or India or wherever else it may be. So we respectfully submit that that is the answer, that indeed the simple point is that either the minister had power to do what he did, or he didn't have power to do what he did. May I turn to the issue of remedy? What we have heard, Chief Justice and Justices, with respect is no answer to the point put by Justice Nkabinde, is the departure point, assuming that one is held for unconstitutionality, that the remedy must be effective. And that I understand to be the jurisprudence of every constitutional court, Supreme Court in this region. That people don't get given gold stars, they don't get given nothing. The predicate, of course, is that something has happened which is infringed a constitutional right. Then the question is, what makes good that? Well, we are given this answer by our legal friends. First of all, may I say that my own understanding of Article 25 and of the judgment in Cran is that this court has no discretion if it reaches a conclusion that conduct is contrary to the Constitution. As in South Africa under Section 172, the court is bound to declare it unconstitutional to the extent of the unconstitutionality, or the inconsistency of unconstitutionality. However, it does have the power, as appreciated in Cran, to mediate that. So the first step is...
Which is a timing issue.
With respect, yes. With a timing issue, it's not saying as our learned friend ended up suggesting, that actually, as a relevant factor, we'd made allegations relating to our 15 polling stations, and he counted, and I'm afraid I either lost ability to count or follow, but that it reduces to 7. Therefore, we had made exaggerated contentions or something in relation to some. You don't deny people the consequence of unconstitutionality on that kind of basis. That really, with respect, is going low. The crucial thing is you start with the fact that Article 25 says the court would have to pronounce, and the predicate, as put by Justice Nkabinde to our learned friend, is, right, if the court is persuaded, and I'll come to that in fact what happened was not consistent with the Constitution, what is an effective remedy? Well, first of all, it must declare, we respectfully submit, unconstitutional. But what do our learned friends ask for? And the Chief Justice was seeking hard for a clear answer on this. The court is still not assisted with what we would have thought would have been within the province and the responsibility of the governmental respondents to say that if we are wrong, then this is what we say is an appropriate order and to defend it. What we have is their heads of argument in paragraph 93, where they say, if a declaration is granted, the appropriate remedy is to suspend the declaration of invalidity and or unconstitutionality and allow the minister the opportunity to rectify the defect in his determination. With respect, this is confused at every level. What we have suggested as relief is the simplest of all and the less intrusive for the court to order, which is, if the court is with us, then the prayer we ask, I think it's prayer 6, as Justice Smuts pointed out, I'm not very good at my numbering or recollection of the numbers. It's simply directing the conducting of a fresh presidential election compliant with the Constitution and the Act without undue delay. What does that mean? It means it leaves the power with the minister to decide, well, do I now do that, which I was advised in 2014 was a good thing to do, 15, again in 2016, and which I was told in the letter of February 2019 was actually the way to go, but there were problems. Do I do that and remedy the problem by putting into effect 3 and 4? We submit the court won't tell him what to do. The court will leave that with him. In February last year, there was talk about needing regulations. The Electoral Commission has been deficient in assisting the court as regards putting up an order to it. We don't know if it's been deficient for what is now 11 months, and it hasn't, on a preparatory basis, made those regulations. We don't know also if the Electoral Commission is capable, as our learned friends and members of the court and ourselves are working through the night and weekends, to remedy that problem. The short point is, it's not for the court with respect to dictate to the executive what to do, least of all under 94B of the Constitution when it's an independent electoral body. What can happen is one of two things. One is that without the sky falling, a ballot may be conducted as it has been and is across the region in the old way. Got its problems, but you'll notice not a word says it can't be done. It's got problems, of course, but not that it can't be done. Or the other is that we hope very much that the Minister and the Commission haven't sat back, knowing that there was this challenge, knowing since last year that there was no regulations. We would hope that they're capable of, within 24 hours of the court handing down of judgment, saying, well, we've got the choice. We do want to go with the voting machines. We will go with the voting machines, implement those measures, and we can remedy it in some way through the regulation. It's a choice. I would think that more sensibly they would realize, if they've, as one would perhaps infer, not done that, then they would say, well, this election would have to be conducted as it has in the past and as others have been done. So we would respectfully submit that's the situation which arises, really, shortly speaking, on remedy. And it's with respect not for the court to be a nanny to the executive, that the executive is capable of deciding on these options, and this court, ironically, also on a separation of powers, would not want to dictate in that way. It wouldn't want to say you hold an election this way or the other. On remedy, may I just make these last few points? It said that we should be left only with an empty declaration. That's not an effective remedy, number one. What is the reasoning offered? Having not been grappled with that departure point, is that since 2014, this has been, this has stood. But yes, but the same organizations have been accepting publicly that it's not good, it should be rectified. They haven't rectified, and the documentation before you, as I say, suggests if they'd only gone to another supplier who would give them 95% verifiability, there wouldn't have been this case. Third point they make is they relied on Maletsky. We hear this all the time in this case, that this judgment of a single judge in the High Court is somehow some tablet from Mount Sinai, some tablet from Moses, which establishes the law in terms of which the minister and the commission are entitled immutably to act until such time as it is, as it's put, set aside. Judgments are given every day. Sometimes they're for you, sometimes they're against you. It's a matter of consideration as to whether a judgment is right and whether it is thought that it would sustain a period of time. But it's going back to effectiveness and the default position of objective constitutionalism. How can it be a reason to deny the voters of Namibia the protection which Parliament said they must have, because there's been a drifting single judge judgment which the Commission thought had this particular status? Lastly, and it's the only real point, is the question of prejudice. Our learned friend said, well, it's covered, we say adequately, and I've dealt with that, the financial implications. But he says nothing about the other prejudice, and that is voters, as my clients, and let me use the plural, as my clients have said to me, there are people who are confronted with this, and they don't know that their vote is safely recorded. Our learned friend says, well, there's also a printout from the machine. Well, that's the same level as Mr. Rao says, if there's a challenge, you can open up the machine and look in the machine and see if there's something wrong with the machine. It's not what Parliament said. Parliament said is run a parallel check, which is that which doesn't rely purely on the machine's software. It captures your vote, prints it out, and you can't fiddle with it. It's there. So the prejudice has been suffered. To remedy that prejudice, there should be an election held being compliant with law. What's compliant with law, we would hope very much the Commission and the Minister displayed some energy and prepared for preemptively. Since our learned friends suggest nothing, we would suggest one thing, and that is, and I'd raised this in my earlier argument, there was no response, there's nothing before you as to why that should not take place within 30 days. We ask for that to take place within 30 days. If the court differs and believes it's 45 or 60, then so be it. Also, we've said in answer to questions from the court, we would see nothing wrong in providing the kind of mechanism which, again, inexplicably, the respondents haven't asked for, but to say that all things done up to the declaring of the outcome of that new election shall stand in terms of the validity problem. It's not for me to formulate, but that is the approximate formulation that we are giving. And lastly, our learned friend repeated the untold chaos point. There's no factual basis for that. It's not a responsible submission. So we submit as regards remedy that would be the answer. Justices, may I then revert to where the argument began, and that is the raising arduously of the jurisdiction and then the unreasonable delay, the urgency, Odicron. Let me deal with them very briefly, if I may, in this way.
Before you go
Sorry.
into
I would think every word in the founding affidavit, Justice Nkabinde, I would hope, goes to that conclusion. We will look for something more exact, but let us be with respect clear. There is the phrase which is found form in most constitutions and often in the political analyses which follow as to whether the election has been free, fair and credible. Those three words are used. But the legal inquiry is whether the election has been conducted. Before you can't parachute out of the law into a sort of a holistic assessment and have it answered for us by election observers or journalists. The first thing would be, what law was made by Parliament congruent to the constitutional obligations? And we have that. And that law said, effectively, as I argued, that you can have electronic machines, but then you must protect people, and you must protect them from threat. And so we would say there's not a free, fair, if we want to put it in those terms, or credible election, unless those checks and balances are there. And in fact, my attention's been drawn to the fact that it's exactly what the Indian court said in its judgment, which we've referred to in our heads of argument. The paper trail is there for the free and fair election for the two reasons. A, you can check as a human being when you're voting, and secondly, that you have that proper check and balance. And you don't have to climb into the inside of the machine to check whether the machine is doing the right thing, when the machine will tell you, yes, I'm doing the right thing. And Rally for Democracy, we refer to in paragraphs 71 of our case. Yes. Yes. And my learned friend reminds me that this court in Rally said that the counter check was for a free and fair election was the paper trail. So it's exactly Justice Nkabinde's point. It does actually, in terms, link the holding of a free and fair election to having a paper trail. This court has already held. So, Justices, may I then pick up again on this jurisdictional point? May I be short about it, because we have been much cuffed about the head with the contention that we have talked about primary relief, and the argument for the other side we respectfully submit in the end, not by intention but by result, is cynical in that it works this way. It says that we ask for prayers 2, 3 and 4. We ask for prayers 2, 3 and 4 because we need 2, 3 and 4 before we can get to 5 and 6. And then the point is, that 2, 3 and 4 fall outside the exclusive jurisdiction of this court under section 172. And we are told that we have said that our primary relief is 2, 3 and 4. We've done a word search of our heads of argument, our founding papers, and our replying papers. The word primary relief, or words, are the second and third words in our learned friends' heads of argument. They are also paragraph 20.4 of the answering affidavit, to which we replied in the replying affidavit. And we said, no, this is... And as Justice Nkabinde reminded our learned friend when he read the first 3 sentences of paragraph 6 of the founding affidavit and stopped reading, that what it goes on to say in the 4th sentence of paragraph 6 of the founding affidavit, and then spells out, I think, in paragraph 8, is that we are saying that there was no election conducted compliant with law, that the challenge we make is based on that. And what we have done is either through need, and our learned friends say it's need, and it's a very contentious point, through need or through excess of caution, we have asked for antecedent, anterior, preceding declaratives, so that there would not be this argument that of course we get thrown at us anyway, which is the electoral type argument saying something stands until it's set aside. So what we wanted to do was play open cards, say our attack is on the outcome. Our attack on the outcome is because what has happened is that the minister, as the first historical step, decided, mistaken or not, decided not to implement 3 and 4. The Electoral Commission, which actually, this is important, is not bound by the minister. Under Article 94B, it's an independent and impartial body which should have said to the minister, look, there's a problem if it was properly advised. Not do what it did in February, write a letter to the minister saying, aren't we lucky? Since you didn't get put in the safeguards, there are no safeguards, so we can run it on our 2006 model machines, which are being held to be illegitimate by the Supreme Court of Namibia, being fixed in India, but luckily we don't have to do that. What the Commission should have done is at that stage, exercising its own independent function, should have said to the minister, there's a problem. Didn't do that. But the 2 discrete steps are these. The minister, first of all, should either do the duck or no dinner thing on the electronic voting. You either do what Parliament says, or you don't do it. If you trigger the possibility, that's all it is, for electronic voting, then you do it as Parliament does it. Then the Commission can pick it up. And then the Commission can say, well, thank you, Minister, thank you, Parliament. We are not in a position to use electronic voting yet. Why? Because we asked the supplier, we rejected this 95% other supplier, we're going to be loyal for some reason to this original supplier, and that supplier can't help us. The Commission could have then had its paper election as every other country has done. It didn't do that. So we must understand the difference between Parliament says this is the law, the Minister says he can, or the Minister is delegated the authority to say when a provisions are implemented, that is not a delegation to the Minister of to take out half of what the legislative provision is, and then the Commission itself as an independent body should look at the landscape and say, well, Parliament doesn't know how many polling stations we are and how bad the road is to Apua or whatever the point is. It's for us to decide whether we should yet go with electronic voting with safeguards. Not this half-baked thing, which is electronic voting because we bought the machines and we managed to get most of them back from these extraordinary loans that we've made, but we're going to use them. So, with great respect, the primary relief point is a point of ascription to us by our learned friends. They like the phrase, and then they say, aha, you can't get to 5 unless you've got 2, 3, and 4. Our answer is, yes, we can get to 5, and we get to 5 on a basis which was debated by Justice Smuts, I think with me and with the other side, and that is this, that we would be fully entitled if we'd said we want 5, and we want costs. They would have come and run this argument, but you haven't set aside the minister, but you haven't dealt with the Commission. We could have said, we are in the position of those in an urgent proceeding against whom you are bringing a power. And on electoral itself, and on the judgment our learned friends haven't referred to, which acknowledged yet again following Black Mountain in this court in Anui, and that's the recent judgment of 6 weeks or so ago in the Minister of Finance Namibia reinsurance case, where this court, through the Deputy Chief Justice writing, dealt with the fact that of course collateral challenges exist and are applied in Namibia. We could have done that. We would have been hit about the head with this point about, well, why don't you deal with the Commission, why don't you deal with the Minister first? So we thought, what we're going to do is we're going to ask for those orders. But we have made ourselves very clear. My learned friend said I said it 5 times, but clearly I needed to say a 6th time, that the essential relief is the setting aside of the outcome. The others are ancillary to it, they lead up to it, and they're not our primary relief. But may we make another submission on this jurisdiction? And that is, even if that were not so, would you have regard to our heads of argument, where we address this in a detailed footnote at page 4? I would ask you to have regard to footnote 14. The first sentence is that contrary to the respondent's contention, the mere fact that the High Court may have jurisdiction in respect of declarations of unconstitutionality of ordinary legislation does not detract from this court's jurisdiction under 172. They tried the same point in Kenya. They said in Kenya, you're attacking the election, but in attacking the election outcome, you're also attacking other things. So you can't come to the Supreme Court of Kenya to attack the other things, because the High Court has concurrent jurisdiction in that regard, or we don't. And you will see in the reasoning, and we get it in the Mwao case, which was quoted there, and it goes through to the more recent case in Odinga, Riley Odinga, and you will see in particularly the penultimate paragraph just above footnote 15, that it was interpreted, and this is the way we say 172 should be interpreted, as giving this court an extensive jurisdiction to deal with a presidential challenge. To deal with a presidential challenge, first of all, that word challenge, as I argued earlier, nobody tried to give you a laundry list of interdict review or anything like that. It was just a presidential challenge. And it must mean that anything which is necessarily, first of all, it's relating to the presidential challenge. So anything which is connected to it. Tested this way, it doesn't mean that. What are our learned friends saying? Our learned friends are saying that we need 2, 3, 4, 2, 3, and 4. We must go away. You must dismiss. We must go away to the High Court, litigate over 2, 3, 4, then come back to ask for 5, which is within your jurisdiction on their approach. When we finished in the High Court, and maybe that is coming back to here on an appeal. With respect, the contemplation was that if you do something like challenge a presidential election, it's so fundamentally serious. This court and this court only should deal with it, and it should deal with it in its totality. So this salami slicing, which has been endeavored by our learned friends, is significant. It is a justified reluctance to deal with the thorny issue as to whether they can really contend that the minister was capable of, in fact, bisecting Section 95. So we submit that the jurisdiction issue, and Justice Nkabinde, with respect, dismantled or disentangled, perhaps more aptly, the composite submission which was being made, that you have a discretion. It was submitted to you that you should simply send us away. Well, first of all, the court has no discretion regarding its jurisdiction. It's given it under 172. It's sworn an oath to apply it. So the jurisdiction itself is as fixed. Secondly, under Article 25, it's got no discretion to determine things unconstitutional. It's bound again, if it finds something inconsistent, to declare it. And Justice Nkabinde then brought out the only area where there is this discretion, and I am, as you can hear, very, very skeptical and concerned about the word discretion in this context, but relates to remedy. That doesn't mean discretion, should there be a postponement for 3 days or 10 days. It's the court weighing up figures, factors, and reaching a determination. So this whole jurisdiction issue is a desperate attempt, in fact, to keep this case out of court, to chop it in half, to send away half, and to say to you, you can't deal with prayer 5 until prayers 2, 3, and 4 have been dealt with through the entire structure of the courts and come back to you. We say that that is wrong. On the discretion point, the court knows at all pay that it starts with Justice Nkabinda's inquiry, what is an effective remedy? Courts give effective remedies. And if it's predicated upon the infringement of a constitutionally required thing, namely that Parliament has spoken, you either take what Parliament has spoken and implement it, you don't do this. If it is something which is of that nature, and secondly, in answer to Justice Mainga, we say it has the serious effect of depriving you of the check and of depriving the Electoral Commission of the audit trail, then that is those are circumstances in which the court would say, on what basis do we not do the ordinary thing to say that effectively there hasn't been a good election? The remedy is have a good election. You can choose which way. Do it with your machines if you've got all the ducks lined up in a row, or if you haven't, then you know what you can do, as has happened in this country and other countries for a long time. May I deal in with the last few points? We don't know what to make of the delay point. Our learned friends have conceded there was no delay between learning of in the letter, I think, of 21 October, and going off to the Electoral Tribunal and then the Electoral Appeal Court. We submit, and they say there's no delay at all, of course, correctly so, in us launching these proceedings. We were in court within days of the outcome of the election. So there isn't a delay there. What is the delay amounting to? Is that they say what we raise is that they have known as far back as 2014. I apologize if this is the 5th time I've said it, but we say on the papers that it said specifically in relation to the first applicant that he's never clapped eyes on a presidential election before. He's a first timer. It's not said so expressly as regards the others through, I would think, oversight. But there's no suggestion, it's not alleged, that they have stood for the presidency of this country at any prior time. And we would respectfully submit that that would be contrary to every aspect of public knowledge. They haven't. And it goes to the fundamental point that if you're not a presidential candidate, you can't challenge what the minister has done. You have no reason to, and in fact you have no locus to do. Then the second point is a point which Justice Smuts put and to which there was an inadequate answer. And that is, if you're being assured by the Electoral Commission, which has the capacity to deal with this problem in its connection with the minister, if you're being assured, we like a paper trail, we know it's the right thing to do, we're going there. And the first you hear about it is on the 21st of October, 5 weeks before the people go to the polls, that in fact you can give up on that hope. With great respect, then, in these circumstances, to talk about delay. And the last factor is our learned friends disregard Justice Smuts' judgment in SAPA versus in National Namibian Poultry Industries case, a lot of feathers. And it concerned about delay. And Justice Smuts held for this court that it's only the most egregious delay which would be right for a court to dismiss a proceeding without any regard to the merits. And that the other factor that Justice Nkabinda was probing, what is your prejudice? There's no prejudice to them. The attitude that they adopted was that they were entitled to do it. Now they turn around and say what we should have done is attack them sooner. That's not prejudice of a kind. There's no lost trial facts. Our learned friend talks about our delay is bad. Yes, it is when you lose witnesses and documents, etc. But on the challenge as we have framed it before you relates to the election outcome. There's nothing lost. There's a legal point on our central contention that it's either right or wrong. Urgency, our learned friend rightly with respect suggested there's nothing further to be said about it. Maletsky, I would hope we have all in this court said and heard enough. And lastly, it leaves effectively the merits of the point. Our learned friend contended on the issue of the minister and what he did under Section 97, that there's nothing invalid to delegate certain functions to the executive. We have to be careful. You can't have a Henry VIII clause. Parliament can't say you're a fine minister. You could implement that substantively, which is not the law. On Darwood, in all the cases, what Parliament can do, as was held in pharmaceuticals, as Justice Smuts pointed out, very different situation, is to say, we're not on the ground, you the executive are on the ground, we've made the law, you can implement the provisions at certain time. Not that you can chop them up and choose which ones you wish to. Justice Nkabinde asked with puzzlement, why was the court being taxed with the legal opinion of my client, my first client, the first applicant. And with respect, the question was well placed. It was done with what respect as a jury argument to say that our first applicant had seen Maletsky as an obstacle. As long as it stood, there was not much that could be done. I have the greatest respect for the first applicant and all the applicants at every level. And I know that he is also a fellow of 2 Royal Societies in Scotland. But he would understand if I say that I don't necessarily have the same respect for the legal views which are expressed in that. And on this court's judgment in Swakop Munt Airfield, 2013, Volume 1, NR 205, Supreme Court, Para 62. If it's wrong, it's wrong. The court's not impressed to be told that somebody contended this was the law, is the law. It either is the law or isn't the law, and that follows, for those of us with an older disposition, Paddock Motors versus Igeson in the 70s and 80s. And also Lexcor, Justice Nkabinde will probably remember Lexcor versus Richtersveld, where at paragraph 64, Justice Langer said the same. When they're wrong in another court, what the counsel said doesn't matter. What is the law? So there we go. On the irregularities, may I just say this very shortly? We brought the case because there's evidence of irregularities. We tabulate in the replying affidavit that when, in fact, all is said and done, there are unanswered questions and there are indications that the machines are defective. My point was that we are cognizant of the terms of Section 115. And we, before this court, said we put our weight on the failure to comply with the required principles under Chapter 5, which, as Raleigh said, is per se fatal. You don't also have to show 1 million stuffed ballot boxes or whatever. That's what we endeavored to say. There was no wickedness in it. We made out a case, and the effect of Section 115 is that the onus then shifted to the other side in relation to the case as pleaded. Chief Justice, Justices, we have taxed your patience considerably, and I know everybody in the court would be enormously grateful, and we had occasion to express this personally to the registrar, to the enormous efficiency and application of the court in managing to convene in difficult circumstances. And I will apologize, but only vicariously, for ruining everybody's Christmas and New Year. Thank you.
Thank you.
What a day, Jemima.
Indeed, what a day. What an exciting time in our history.
So what we do know is that judgment is expected on the 6th of February. Chief Justice Peter Shibute said that if the ruling is available before then, it will be delivered before the 6th of February. Thank you for staying with us. I can imagine that it must have been quite a long day. It must have tested your patience, but we do know this is important for the future of the land of the brave.
Thank you for being here with us then.
Thank you, Jemima, also to you, and thank you to the viewers for staying with us. From our side at NMH, that is Rikain Algemene Zeitung, Namibian Sun, as well as Windhoek Express and Irongo. It's goodbye.